Welcome to K&L Gates Working Wise podcast series. My name is Amy Groff, and I'm a partner in the Harrisburg office of the firm's Labor, Employment, and Workplace Safety practice area. I'm joined by my colleague, John Vaitl, who's also a lawyer in the Harrisburg office. In this podcast, we'll discuss the fluctuating workweek method of calculating overtime and the Pennsylvania Supreme Court's recent decision in Chevalier versus GNC, holding that this method is not permissible under Pennsylvania law. John, I understand that the fluctuating workweek method of calculating overtime is permitted under the Federal Fair Labor Standards Act, or FLSA. As a starting point, could you describe that method and what it involves?
The fluctuating workweek method is recognized under federal regulations as an option for paying overtime to certain non-exempt employees who receive a salary and whose total hours fluctuate from week to week. We normally think of overtime as a requirement to pay time and a half after 40 hours in a week. In other words, straight time equal to the employee's regular rate plus an additional 1/2 of that rate as an overtime premium for every hour worked in excess of 40. Under the fluctuating workweek method, where the salary is intended to cover all hours worked, that salary is said to compensate the employee for the straight time portion of every hour in the week, including those over 40. Then, to determine the additional overtime premium due, in other words, the additional half-time due for each overtime hour, the employer can perform a fairly simple calculation. First, the employer divides the total salary by the total number of hours worked in a given week to arrive at the regular rate, essentially the average hourly rate for that week. Then the employer can multiply that rate times 1/2. That half-time rate is then multiplied by the number of overtime hours in the week for the total overtime due. Under this method, the regular rate upon which overtime is based fluctuates from week to week, and the rate actually decreases as more hours are worked. However, one critical component to a fluctuating work week permitted under federal law is that generally, the salary cannot be reduced if the employee works less than 40 hours. It must be a fixed salary, not subject to change based on the number of hours worked. The employer should also document the arrangement in writing so that there is no question that there is a clear mutual understanding between the employer and the employee that the salary is intended to compensate the employee for the straight time portion of all hours worked in a week.
Thanks, John. That's helpful. For employers in Pennsylvania, the Pennsylvania Minimum Wage Act also sets forth requirements regarding minimum wage and overtime that in some cases go beyond what's required under the federal law. How have courts previously addressed the use of this fluctuating workweek method to calculate overtime under the Pennsylvania Minimum Wage Act?
Before the recent case involving GNC, no Pennsylvania appellate court had opined on the question of whether fluctuating workweek method would be allowed under the Pennsylvania Minimum Wage Act, and the regulations under the statute do not specifically address it. Several federal district court cases in Pennsylvania, however, have held that the fluctuating workweek method would not be allowed under the Pennsylvania state statute.
Then that brings us to the case the Supreme Court of Pennsylvania just decided on November 20th, Chevalier versus General Nutrition Centers, Inc., or GNC. Can you tell us about that case?
Sure. This was a class action brought on behalf of current and former store managers working at various GNC locations. The store managers were all paid a fixed salary but worked fluctuating hours. GNC paid overtime according to the fluctuating workweek method. Initially, the plaintiffs raised two issues. First, they said their regular rate should be calculated by dividing their weekly salary by 40 hours, not by the actual number of hours they worked. And second, they maintained that their overtime compensation should be calculated by multiplying their regular rate by 1.5. As the case made its way through the courts, however, the plaintiffs ultimately agreed that their regular rate should be calculated by dividing their salary by the total number of hours they actually worked in a given week, not just by 40. The question before the Pennsylvania Supreme Court, therefore, was how to calculate the overtime premium. Both sides had amicus support. The plaintiffs pointed out that the Pennsylvania Minimum Wage Act simply did not include the language of the FLSA that allowed for the fluctuating work week, and that overtime pay must be 1.5 times the regular rate. GNC argued that the Pennsylvania Minimum Wage Act borrowed heavily from the FLSA and that the two laws essentially have a unity of purpose. GNC also argued that the plaintiff's calculation essentially amounts to a double counting of the overtime hours. That is, the straight time portion of the overtime hours are already accounted for when the regular rate is calculated. By multiplying that rate by 1.5, the plaintiffs will be including the straight time portion of the overtime compensation a second time, resulting in overtime being paid out at 2.5 times the regular rate. The Supreme Court acknowledged that both readings are plausible and that the State Minimum Wage Act is ambiguous. Because of the ambiguity, the Supreme Court carefully considered the background of both the FLSA and the Pennsylvania Minimum Wage Act to determine what the federal and state legislatures were trying to accomplish. The court noted in particular that the Pennsylvania legislature, when it enacted the Pennsylvania Minimum Wage Act, used pretty strong language about wanting to help employees from what the legislature called, quote, the evils of unreasonable and unfair wages. Based on that understanding, the court ultimately determined that the fluctuating workweek method is not permitted under the Pennsylvania Minimum Wage Act, and overtime must be paid at 1.5 times the regular rate.
So what's the practical implication of the GNC decision at this time?
Quite simply, employers should not be using the fluctuating workweek method of calculating overtime for their non-exempt employees in Pennsylvania.
Are there any legislative developments that could impact the fluctuating workweek method under Pennsylvania law in the future?
There are. There have been efforts in the past to align Pennsylvania law with the federal FLSA. Most recently, Senate Bill 79 proposes to amend the Pennsylvania Minimum Wage Act to, among other things, provide that the minimum wage and overtime requirements of the State Minimum Wage Act must be applied in accordance with the FLSA and its regulations, unless a higher standard is specified under the State Minimum Wage Act or its regulations. The Pennsylvania Senate voted 42-7 in favor of the bill on November 20th, so employers should certainly keep an eye on this bill or similar legislation in Pennsylvania.
That's certainly good to know. What about at the federal level? Are there any developments that could impact the fluctuating workweek method under the federal FLSA?
Yes. Earlier this month, the U.S. Department of Labor proposed to amend the regulation addressing the fluctuating workweek under the FLSA, which is found at 29 CFR 778.114. The proposed amendment would make clear that employers using the fluctuating workweek method can still pay additional bonuses, shift differential, or other payments without losing the ability to use the fluctuating workweek method. Under the Obama administration, the Department of Labor had taken a different position, concluding that such additional payments were inconsistent with a fluctuating workweek model. However, it's important to note that these payments, such as certain bonuses or shift differential, can still impact the regular rate. It would need to be factored into that calculation. For example, if an employer uses the fluctuating workweek method and also pays a non-discretionary production bonus, the calculation of the regular rate would involve adding the bonus and the salary and then dividing that total compensation by the total hours to determine the regular rate upon which additional half-time would be based. Again, though, this fluctuating workweek method for now is not permitted for Pennsylvania employees.
Thank you, John. This has been very helpful. To our listeners, we hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com or search for our standalone Working Wise program. You can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.